Hello friends, this is Amol here, and I'm trying to maybe demystify for those who don't know, and for those who know, revisit some topics from commercial contracting. And today I'm going to talk about liquid damages, just one of the most common terms we hear from the commercial contracting world. So yeah, it's not, of course, not liquid in terms what it might appear. Rather, it's the same liquidity what we talk in the market when we want a liquidity, that means ready money or in terms of money that's easily available to transact. So that's the liquidity we are talking about, and that liquidity in this case refers to something which is readily available. Okay, so readily defined, readily available in terms of money, of course, which is easy means to transact, or thing which is easily available to use, right? So that is liquidated. And damages, of course, damage has different meanings in plain English, but in commercial contracting world, damages means the compensation for breach of a contract. So contract means obligation from either party, and one of the party breaches or don't carry out those obligations, the other party is entitled to compensation, right? So that's the damages we are referring to over here. So that makes a complete sense now. Liquidated in this case, as we see, something which is worth some value and it is already defined. So you can also call it predefined damages. Yeah, and that is basically it is for predefined damages by the parties in a contract for breach of a contract. And most of the times, both the parties really know certain important things, and if they do not happen on that time, there'll be certain consequences, and of course damages, which, because these parties know, they define it, right? Most of the times it could be in terms of pure number, in terms of currency, or it could be also a percentage of amount of equipment that is being dealt under the contract, or it could be also percentage of the entire contract value also, depending on different types of contracts undertaken. So that's about the basics of it, and that's how it is normally defined inside the contract. So actually it's the practical part of it. Okay, so that's just little bit understand from theory perspective. Now coming to the practical part of it, what it is giving, or rather of a value to you and me as having it in a contract is that when it is happening, things are all good when we are making contracts, of course, right? Everybody wants to have that business from either party, and the things are good, but when things are not so good, right, it's very difficult to have a common agreement between parties on what could be the damages, right? So if one party puts it, other party will say no, it's not, either it's not applicable, or if it is applicable, then the values inside are not real life, right? So a lot of issues to get to an agreement in that case. So the good part is that when you are on good terms, that time only you define these values, and so it's already predefined. Both the parties are agreed, so there is no tussle to get it agreed when the things go wrong, right? So that's one practical aspect of it having, or the rather value of it having it inside the contract. And as I said, it's predefined, so both the parties have agreed. So contract, the law of contract gives you freedom to contract for of course for reasonable things what you are doing under it, right? So this is just one of them. And so we talked about the basics of it, we talked about the practical value of it, and now we talk about little bit about the law, right? So most of the times, if you go for an agreement or contract finalization, most of the people, commercial people, will say, okay, it's a commercial term and let us handle it, right? So that's most times understanding, because it's a commercial value, and negotiation of it is of course of commercial nature. So business people understand rather what could be the damages, what are the values involved. From that perspective, it's all good, right? But then when it comes to law, there is angle to it, and that another angle is it touches upon the law of contracts. So say for example, a common law country like India, where I come from, basically, the Indian Contract Act, right? So where this part is captured. So it's important to look at it also. So, for example, I'm just referring to the Contract Act, which of course you can get online over internet easily. It has got section 74, which is basically compensation for breach of contract where the penalty is stipulated for, right? So, of course, you defined it in the contract, but during the process of litigation, does it stand good, right? So that's the question. That's the question of law, right? So, so the section 74 clarifies that, right? And what it provides for basically is that you can have predefined damages in the contract. Only thing, so on one way, it's giving you freedom to do that as expected, in a more so in common law country, to parties to have freedom to define what they want to have under agreement, right? So that freedom is maintained in here. At the same time, what section 74 is providing for is having a role of court to decide whether that compensation defined there, predefined, is reasonable or not. And why is that? It is because the courts don't want to, or the rather act or the law doesn't want you to have penalties there. So when it's a penalty, it's different than damages. So damages basically is what compensation for the breaches, and penalty is basically something not, doesn't have to be a reasonable compensation. It could be, actually it is most of the times it's more than that, as kind of a deterrent, right? So, and that's not, that is what you would not earn basically, if there was a breach. So from that perspective, to prevent that unjust enrichment, the law doesn't want to have these penalties in there, right? So that's a little bit different between penalties and damages. And of course, the penalties are not what law wants to give it over here. Rather, it wants to avoid reasonable damages, what you define. So So crux over here is whatever reasonable damages you define over here will get granted. So they are valid, hold good under law. So that's all good from legal perspective. Whereas if you are defining some not really damages but penalties, those will not stand good, right? So but still, I mean, say it doesn't make that entire clause invalid. It stays there. Only thing that would happen is your compensation will be judged in that case, whether it is reasonable. In that case, it is not reasonable, then what is reasonable, right? So getting into it rather than straightforward granting of whatever predefined reasonable damages, right? So that's a good thing to have, rather than spending time on scrutiny, which is undesirable, to rather have straightforward reasonable predefined damages, rather than sounding it or making it look like penalty, right? So that's the legal perspective involved, which most of the times commercial people might overlook and may need a help of a little bit understanding of contract law of that country, or maybe a lawyer in case you need that help if you don't know about it, right? So so this effort, what I'm trying to do, to refer just one section of of a contract doesn't is not the entire thing around. As per when you say law, there will be case laws, of course, where the law gets developed from. So there are other things, but this is basic act which is relevant over here, and that's what I just discussed now, right? So summarily, we just saw the basics of liquidated damages, its practical value, and just have a little bit look at it from legal perspective also, right? So with that, I would end at this point on this topic. I'll come with another interesting term or another interesting topic in my next video. Thank you very much.